is Salvador Herencia Carrasco. I am Peruvian, and I am currently the director of the Human Rights Clinic at the Centre de Recherche et d'Enseignement Droit de la Personne à l'Université d'Ottawa, and a part-time professor at the Département de Droit Civil of the same university. I've been working on human rights, on international criminal law, and inter-American human rights system for almost 20 years in different capacities, both at the NGO level, at the state level, and at the Constitutional Court. Yes, we recently published, it was a regional study for the Andean region, so that means Bolivia, Chile, Colombia, Ecuador, and Peru, and on the field of business and human rights. So the main purpose was to focus on the third pillar of the UN Guiding Principles on Business and Human Rights, which establishes that the states and corporations must adopt or create measures for a swift reparations and access to remedies of victims. So the main element that we tried, this is a first review on this matter, because the issue of business and human rights in Latin America has mostly focused around the adoption of national action plans, okay, or the implementations by corporations of the OECD guidelines on multinational corporations. But for any law to have significant impact, you must have appropriate remedies and recourses. So part of our job, or part of this research, was to identify what is the field, what does the current legislation, the current practice has to offer for people whose human rights have been negatively impacted by businesses' activities. And we have two major conclusions. One, or three. One, that the decisions of the Inter-American Court of Human Rights have not necessarily addressed this topic yet. So there is a void that needs to be filled. Okay? And hopefully in the next year or so, there will be some decisions that are addressing the issue of remedy and access to justice in the field of business and human rights for state obligations. Secondly, that there are many cases at a national level related to business and human rights, mostly mining, oil, and gas against indigenous peoples. But most of these cases have been presented at the constitutional level or within the constitutional field before constitutional courts. And a significant peculiarity of the constitutional courts in Latin America is that their main role is to restitute rights, but they do not award reparations. So even if a decision by the court does not award tells you that you have a right has been breached, if you want compensation, you need to take it to the civil courts to find a compensation for a labor violation, etc., etc. So a field that we have been discovering is actually our civil legislation, our civil codes, and the responsabilité civile extracontractuelle, that, as probably you may know, there is a strong influence from the Napoleonic codes from the 19th century. So la responsabilidad civil extracontractuelle, the notions of due diligence, and the important thing is for us to identify how these non-judicial remedies under civil courts can actually benefit public interest litigation in the field of business and human rights, that for the sake of victims requires also includes possible reparations. So I think that the overall message of the court of the study was to identify what are the challenges, but to identify possible opportunities regardless of a needed implementing legislation in the future. And we conclude that we have tools pretty much in all the countries that we studied to actually present cases for business and human rights abuses in civil courts, which would be under tort, that would be determined in the common law world, which could benefit victims in the issue of reparations. there's one important decision that specifically addresses home state responsibility or extraterritorial responsibility. It is in the advisory opinion of the Inter-American Court on the Environment and Human Rights from 2017. This advisory opinion is also available in English in case anybody's interested. And this court, and the court, in let's say no more than a page and a half, 2 pages at the most, pretty much states that home states have to assure or make sure that the corporations that are based in their countries do not their activities do not impact negatively on the human rights of populations in the host country. Okay, so in a way, it is interesting because it is pretty much the language that many UN treaty bodies have stated, the Committee on the Economic, Social, and Cultural Rights, or the Committee on the Rights of the Child, just to put 2 concrete examples. But usually when those decisions were adopted, you're thinking about a north-south divide, the global north, Europe and North America versus the global south. But because of the advisory opinion is within the Latin American countries, it is interesting because you do see a lot of home states that are part of the American Convention of Human Rights that actually should adopt specific measures on due diligence, on supply chains, to avoid that their activities do not impact human rights of populations. Just to mention, Mexico, Colombia, Peru, Brazil, Chile have huge multinational corporations that are operating within the region. So, but because I think that we have a north-south approach to home state responsibility, we sometimes forget that within the global south, many of these problems are replicated. So I think that although the court doesn't go into that level of detail, and the advisory opinion just focuses on the environment, there are strong elements that are setting the foot in the right direction, which is opaque with the decisions or with the reports of the Inter-American Commission of Human Rights that has adopted 2 thematic reports, one of extractive industries in 2016 and another one on business and human rights in 2020, that pretty much state this element of extraterritorial obligations, although in their case they're more I think the direction was towards the North American countries, right, within the Latin American Caribbean countries. I think that's a very, very interesting question, and trying to be as concrete as possible, the answer would be no. At least not that I'm aware that there has been any accusation of imperialism by the court vis-a-vis indigenous peoples. Okay, there have been accusations of affecting national sovereignty and going beyond the scope of the American Convention by states, but that is a different problem. Okay, that not applicable to this case. What I have seen in my personal experience, okay, is whenever I work with any indigenous peoples, okay, their main question is, how do I exhaust local remedies so that I can seize the inter-American system? So that is, in a way, I think that because they have the issue of imperialism and colonization, I think is focused at a national level, right? The role of the state, the role of security forces, right? The concept of the common good applicable for economic development, right? And they see the inter-American system and international human rights law as a whole as a place where they could actually have their voices heard. So theoretical discussions aside, okay, about how international human rights law is embedded into a notion, an imperial notion of international law, it is interesting how this promise of human rights, from many indigenous peoples, they see the Inter-American Court of Human Rights with all the problems that they have as a solution. So I think that most indigenous peoples, that or at least the people that I have worked with all over the years, see the court as a place, and this hurts me because they see it as a place where their voices can be heard. And as we are celebrating our 200 independence in many countries, 200 years of independence throughout Latin America, the fact that they see the state as a place where their voices cannot be heard, or that they're not subjects or citizens, it's something that is painful, and it's something that should give us a hard look of the changes that we need to move so that we can include them in the everybody can be included and feel represented by the state. I think that the main contributions or advances of the system, first, that the system has really included the notion of civil society as a part of the system. And these are not, political punchlines or pretty discourses. Many of the changes that they have done in the rules of procedure have been to simplify and facilitate the access, of indigenous peoples and victims as a whole, to the system. The same thing with those interested in public interest litigation, where really civil society, and here include victims, human NGOs, academia, can play and could play a significant role in the system. The second contribution has pretty much been that it has, in the judicial adjudication, there's a theory of, the Constitution as a living tree, so that you don't have to constantly amend a constitution or a document, but the Constitution must be able to adapt to the current legal challenges. I think that judicial theory, which is pretty much North American legal theory, has been applied to the American Convention. So if you see the two protocols that they have, is one that was adopted in 1998 on economic and social rights, and the other one for the abolition of the death penalty. But all the other issues regarding refugee rights, indigenous peoples, violence against women, so on and so forth, have been used under the American Convention of Human Rights. So, and without needing to adopt or amend an international treaty, it has been the power of the case law that has pretty much met a 1969 document trying to meet the requirements and the needs of in 2021. And under that, I think that another contribution of the system as a whole has been to benefit our monist legal traditions, in which international law is part of our national legal systems. So in that way, it creates a strong relationship between international law and international standards with national legislation. If we were a country with a dualist tradition, perhaps the impact would be significantly inferior, right? And the third contribution is that we have stayed away from the margin of appreciation. Our reparations are clear, cut, and direct, but no margin of appreciation here. Shoot, and you can leave that on the interview if you want. Structurally, the delay in cases, it is becoming a serious problem, and the system has to, you cannot wait 10-15 years for a case to go from your initial petition for a case to be submitted to the court, and that is not access to justice. Okay, and that is why I think that we are not paying enough attention to this issue. We comment on the legal decision, if we comment on the standards that are being created, but what does 15 years waiting for justice means for victims? And I think that we're trying to address systemic inequalities, which is great, and that is the raison d'être of all the complex system of reparations that has been jurisprudentially created. The system of non-repetition guarantees are not stated under the American Convention. The American Convention says if a state is found responsible, reparations might be ordered. That's it. But all issues, rehabilitation measures, non-repetition guarantees, so on and so forth, are all jurisprudentially created. Okay? But 15 years waiting is not justice. And we need to focus and we need to demand that all these cases to be swiftly addressed, even if it is to be dismissed. Okay? And subject matter, COVID-19. The impact of COVID-19 on the enjoyment and protection and guarantees of human rights. For example, there are no vaccination plans with an intercultural approach. Where are indigenous peoples in the line of priority? Once we get over this pandemic, and we will get over this pandemic, the states will have the need to reactivate their economies as soon as possible. This means one thing in concrete. They're going to strike down environmental regulations and they're going to strike down human rights regulations because we need to get the economy going. How does this impact human rights of indigenous peoples and of vulnerable groups as well, any other vulnerable groups? So these are problems that we should be thinking now, because if we wait a year or 2 years, not much will be done. There's not much that we will be able to do. So I think that the impact of COVID-19, not only seeing as how it has increased the inequality, the social inequality gap, but how there is an equality at a national level on vaccination procedures on vulnerable groups, but also the impact of the economy, the need to reactivate the economy will have on those that are already financially, economically, and socially at the bottom of the social pyramid. The lack of musical concerts. I think, but on a serious side, COVID-19 is a serious look in the inequalities of our system. Okay, and Marion and Maël, in no way I'm trying to say abolish capitalism. I know there are many people that say that, and they're entitled. They have very solid arguments. I know that, for better or for worse, our countries need extractive industries. There's no social programs without them. Okay, but my concern is how COVID-19 has shown us in our faces the inequality and the social gap of all countries. And I'm actually hopeful that this could also present an opportunity for us to adopt the measures that are needed to close this social gap. Okay? And our states, our countries will recover. We will see our families again. But it is what are we going to do with the unfairness of the system? Right? People that have been without incomes for a year or have been, relying on social aid just to get by, includes you as a student, student loans. What does this mean for the system? So what reforms do we need to adopt so that we are better prepared when there is a next pandemic? So I think that is something that troubles me a lot. For any student, okay, you should try to do what makes you happy. If it's tax law, hopefully not, but if it's tax law, but in all fairness, if you want social justice, you need to understand tax and fiscal law. That's where social justice is. right? Not in pretty decisions or punchlines about education. It's how much the state is allocating for vulnerable groups, for health, for education, for pensions, so on and so forth. And secondly, choose what you wanted to do. If it's human rights that you want to do, right? Whether it's within the state, whether it's an international body, NGOs, grassroots organizations, academia, but never lose the sight that human rights is about protecting people and is protecting vulnerable groups. Most of you who are at Université Aix-Marseille have are receiving world-class education. Okay? And you are already at the top of the food chain in many elements. But I would like to always never lose sight about the work that you do can have a significant impact on victims, even if you do not litigate. If you're working on a national action plan, or you're working as a legal advisor in Congress, you are having a significant say in changing people's lives. But I would also invite you, if possible, to try to litigate or try to work with victims in whatever shape or form, because it keeps you grounded at the end. Academia can be an ivory tower where you're thinking about jurisprudence and legal theory, but working with victims always keeps you grounded and helps you understand why you chose to work in this field. In my case, I always knew I was going to be a lawyer ever since, because I sucked at soccer, so law was the second choice. But for me, was looking when the House of Lords in the UK determined that Pinochet should be arrested. For me, that was an opening point, and for me was when the Fujimori regime in my home country of Peru fled the country, and we started to work on a transitional justice model. So for me, those were the two moments to say, this is what I want to do. And I quit a job working on fiscal law at a law firm, at a very top law firm. So, but at the end, whatever you do, be happy, and the rest will follow.